Today's episode is going to be, it's entitled, What Does French Law Say? And we'll get into the details of that in just a moment. The next episode would be, what are the consequences of FrandAvenue for the licensing process? And then the third episode would be, what solutions does FrandAvenue provide? How does this platform solve some problems? And I think that will become clear as we go through the questions and answers here. So, Cyrille, can I ask you to introduce yourself and explain a little bit about your background?
Yes, with pleasure. Well, I'm an attorney at law here in Paris. I've started my career in-house, and that's how I started to become, acquainted with the FRAND and SEP matters. And since then, in private practice, I have negotiated a large number of patent license agreements and litigated SEP agreements many times. And I happen also to have founded the FrandAvenue platform, which aims at providing solutions to the licensing professionals, and especially in the SEP arena. So that's my background. And given this, as you have just said, given this, the size of the topics that we will address, we will do that in 3 episodes. But today we are really going to focus on what is FRAND under French law. I think that we need to start with that in order to better understand what are the issues and what solutions we can find in French law and on FrandAvenue.
Okay, what is your view of the FRAND obligation?
Well, as we know, focusing on the ETSI FRAND obligation, there are other standard setting organizations, but ETSI is the main one. ETSI, I think many people know that it's a French association, a non-profit organization, which is organized under French law. And under French law, an association is a contract between the founding members and the people who are joining the association. So the relationship between ETSI members are governed by the statutes, the bylaws, and all of that has to be construed under French law. And this is particularly true for the undertakings that licensors, SEP owners, and implementers are taking under those rules. That the ETSI IPR policy is part of the ETSI rules of procedure. That's Annex 6 of these rules. And as a member of ETSI, the licensor has, among other obligations, the licensor has declared to be prepared to grant irrevocable licenses on fair, reasonable, and non-discriminatory terms and conditions under such essential IPRs. That's the ground on which all of the SEP and FRAND issues are built. Then the licensor's refusal to grant a license on its IPRs, a license to the implementer in accordance with Article 6.1, can therefore be assessed as a breach of the contract of association entered between ETSI members when they join the association. Reciprocally, the implementer's refusal to negotiate in good faith with the licensor is a breach of the ETSI rule governing the duty to negotiate in good faith a license agreement for the declared SEPs. So such behaviors are assessed as a breach of the agreement between the licensor and the implementer, which is the FRAND agreement, which I will describe in a moment.
Does the FRAND licensing commitment apply only to ETSI members, or is it more broadly available to implementers of ETSI standards?
Let's keep in mind that the undertaking stated in Article 6.1 of the IPR policy is reiterated in each essential IPR declaration, ISLD in our jargon. So it's a covenant or a promise to grant a license which binds the promiser and benefits to the promisees through the mechanism of the stipulation pour autrui, the stipulation for the benefit of a third party, which is now well known, which is really organized by Article 1205 of the French Civil Code. So that mechanism is governed by French law, but that's only a mechanism within which ETSI is the stipulator, the licensor is the promisor, and the implementer is the beneficiary. This is now well settled in most jurisdictions, especially in the UK, in the US, in France, in China, in India, where in each of these jurisdictions, this mechanism has been admitted. And this mechanism gives rise to a contract, the FRAND agreement, which contains reciprocal obligations. It is important to understand that a stipulation pour autrui is just a way of obtaining an agreement. It's not the agreement itself. The agreement itself is something different.
What are your view of the rights and obligations, respectively, of the licensor and the implementer under the FRAND agreement?
Well, under that agreement, we know, because that's expressly stipulated, that there is an obligation to negotiate in good faith, a license agreement on FRAND terms. That's explicitly stipulated, but other important obligations weigh on the parties. As I mentioned, the first obligation, there are at least 6 obligations which stem from this FRAND agreement. The first, as we mentioned, the duty to negotiate in good faith. This is expressly stipulated in the ASLD in accordance with Article 1112 of the Civil Code. The second is a duty of the parties to disclose to each other all information that has a direct and necessary connection with the content of the contract. This duty is expressly stated in Article 1112.1 of the Civil Code. And accordingly, the parties must disclose to each other at least the following information. All information related to the license portfolio, documentation that licensor possesses and which supports his contentions, such as a claim chart for a patent family. And on the licensee's side, there's also a duty to disclose information, and that's all information related to the licensed products, technologies, territories, and so on. The third obligation arising out of this FRAND agreement is a duty to negotiate diligently. And there's a lot of case law in French law on this issue. And this is a consequence of the good faith obligation, as underlined, by the way, by the European Court of Justice in its Huawei versus ZTE decision. This is fully consistent with French case law, which sanctions dilatory negotiation tactics aiming at or resulting in depriving the other party of another opportunity of barring it from using a right that it could otherwise have asserted against the delaying party. And that's all the more important when you have this reinforced duty of good faith, because it's expressly stipulated in the FRAND agreement. The fourth consequence is a right for the implementer to practice the declared SEPs pending the outcome of the good faith diligent negotiations. To this right corresponds the duty and obligation for the licensor to let his patents practiced by the implementer until the FRAND agreement, this negotiation agreement, is terminated or replaced, superseded by the contemplated patent license agreement. And this obligation, which has been observed by the market players since the creation of the ETSI IPR policy more than 30 years ago, is crucial. It has been confirmed by the European Court of Justice in the aforesaid decision Huawei ZTE. Now, there is no free meal. The fifth obligation is a duty for the implementer to compensate the licensor. And of course, there's a right for the licensor to be compensated for the use of these patents during the validity period of the FRAND agreement. Finally, there is, out of this FRAND agreement, arises a direct right to the performance of the contract by the two contracting parties. The creditor of an obligation, licensor or licensee, has the right to demand the performance to the debtor or to seek damages. And this is obviously true for contracts arising out of a stipulation pour autrui. And that's very specifically stated in Article 1206 of the French Civil Code.
So as you know, most of the jurisprudence surrounding FRAND has been promulgated by German courts. The Huawei's ETE decision that you mentioned was itself the result of a referral from Landesgericht Düsseldorf. The decision by the CJEU set forth on competition law principles, a procedure that we call the dance steps, the FRAND dance, which SEP owners and SEP implementers should follow. And there's been several significant FRAND decisions by the Judicial, further clarifying the obligations of each party under the CJEU decision, and I'm thinking of the Cisco behaviour cases. And it's probably sufficient to say that the German courts have viewed FRAND largely on a procedural basis. As I say, whether claim charts are necessary, what constitutes delay, and most of the focus has been whether an implementer has acted as a willing licensee. And that's to say, the German courts have viewed FRAND cases on whether or not there's been a constructive refusal to license on the part of an implementer. Now, these cases are, of course, as in all court decisions, based on specific facts present in the case. But many in the field have taken these as general rulings on FRAND, and these decisions have been largely informed by German patent law and EU competition law. The willingness of the UK and Chinese courts to set global FRAND rates, something which German courts so far have been reluctant to do, arises from a recognition that the FRAND obligation, as you mentioned just now, arises from contract law. It doesn't come from competition law, it comes out of contract law. And I think there's no dispute, I agree with you, that the ETSI IPR policy is governed by French law. It's been recognized by courts around the world, and I don't think there's any dispute about that. And I understand from my discussions with you that French contract law has a somewhat different view than we have been seeing coming from the German courts. For example, if one considers French law, what steps should the implementer take to secure an agreement with the licensee?
Well, I think that's a good summary of the situation. That's probably the drama of this SEP market, where until now, even if substantial progress has been made thanks to a number of decisions, mostly from the UK, the US, and some other places, the main roadblock in this market is that the French law applying to the FRAND agreement has not yet been fully applied. To give you an example, you've asked me if, what steps should the implementer take to secure an agreement with the licensor in the French law. Clearly, to secure an agreement with the licensor, the implementer must show in writing his willingness to comply with the FRAND agreement. This must be in writing because the FRAND agreement contains a covenant not to assert or license to practice the patents, which is the same in the French law, pending the outcome of the negotiation. And under French law, like in many other countries, a patent license must be in writing. So to be fully binding on the licensor, the implementer's acceptance of the FRAND agreement, of the offer to negotiate, must therefore be in writing. This writing can take many forms, such as a written undertaking to take a license sent to the licensor or made publicly available to anyone, just like the ETSI declaration. And that's exactly why, this is the genesis of the FrandAvenue platform. That's, if we accept that the ETSI IPR policy should be considered as a contract enforceable under French law, as we believe it's well settled, the laws of France are somewhat more rigid, as you said, and well defined than the guidance coming from German courts. For example, on FrandAvenue, it's possible for SEP holders to publish a complete FRAND offer through a dedicated account, to publish all the information they have the duty to disclose, and therefore making it possible for SEP implementers to publish their written counteroffer on the same dedicated account. Put it, in a nutshell, our platform makes it possible for SEP holders and implementers of SEPs to comply with the FRAND agreement, which is a good start if you want to secure an agreement.
Well, so if the licensor or the implementer can't agree on FRAND terms, what remedies will be available under French law?
Well, there are different scenarios, but that's pretty easy to understand. If the two parties ask the court to set forth a rate, then the difficult question of the legal basis on which a court can replace the parties, can supersede the parties in determining an essential element of their consent, the meeting of the minds. That difficulty is settled. That's okay, because absent a joint request by the two parties in a litigation, and unless there is a special legislative or contractual provision, courts in many countries, and especially in France, would be reluctant to interfere in the free determination of contractual conditions. Now, the second scenario is, what if one party only, and that's usually the case, either the licensor, in most cases that's the licensor, but not always, or the implementer, asks the court to set forth the FRAND rate. Then in such a case, the court may wonder about the limits of its jurisdiction under French law. And this is where the breach of contract approach is decisive, because the claimant can always ask the judge to settle damages. That's something that judges do every day, everywhere in the world. So clearly, the FRAND rate would form the basis of the calculation of the damages sought for the alleged breach of the FRAND agreement. And the judge would have no difficulty to rule in this matter. And once the contract is terminated and the damages are decided, the judge regains his or her freedom to pronounce a prohibition measure based on patent law if the licensor asks the court to pronounce such measure. And that's where there's many things to learn from the UK courts, because such a prohibition measure can be subject to suspensive or resolutive conditions, such as the finalization of a license agreement under the FRAND conditions used for the calculation of the damages. This is equivalent to the solution adopted by Mr. Justice Beers in the unwed tenant case. And finally, the parties could as well ask the judge to enjoin the allegedly breaching party to perform the contract, not to terminate it, but to perform it. And in particular, the judge could issue prohibition orders, enjoin the violating party to behave in accordance with the contract. So this way, the parties have a much broader array of solutions available to them.
So for which courts of law? For French courts or any court?
Well, in principle, any courts, except that for certain matters, French courts would indeed be the natural judge of the dispute. That's particularly true for actions based upon the alleged breach of the contrat d'association, the ETSI agreement, because France is the place where the characteristic obligation at stake is supposed to be performed. Now, contrary to what certain litigants have done in recent years, a dispute between ETSI members does not need to involve ETSI. There is no need to force ETSI to intervene into the litigation for the French courts to have jurisdiction to adjudicate a dispute about the contrat d'association. Then, for claims based upon an alleged breach of not of the contrat d'association, but of the FRAND agreement, the one that derives from the FRAND undertaking, then among other criteria for the choice of the court having jurisdiction, the place where the characteristic obligation which forms the basis of the claims is supposed to be performed, that place is more difficult to determine. And this is important when you look at the Brussels Convention about the jurisdiction, the court jurisdiction. Of course, the fact that the FRAND agreement is subject to French law does not give exclusive jurisdiction to French courts. For example, a German court can adjudicate a dispute arising out of the FRAND agreement, applying French law. However, the German court would simply have to determine if the agreement must be terminated or not, under French law and not under German law, naturally. In the affirmative, if the German court says, well, there has been a violation of this FRAND agreement, and I rule that it is terminated, then the court becomes free to apply German patent law to the infringement case, because there is no FRAND agreement anymore. And at this stage, there is no need to apply the FRAND dance steps, because if the latter were fulfilled by the parties, then the contract could not be terminated under French law. And, it's very important to keep in mind, at the risk of stating the obvious, that I have seen decisions which were not applying this, so I think it's worth mentioning it, that under the Rome Convention on the law applicable to the contractual obligations, which is now also the EU regulation, quote, the contract shall be governed by the law chosen by the parties. That's a well-known principle. And the convention continues saying the existence and validity of the contract or of any term of the contract shall be determined by the law which would govern it under this convention if the contract or term were valid. This means that the fact that, for example, the contract may not be formed through a stipulation pour autrui in Germany is totally irrelevant, because the German judge has no choice but to apply French law to determine the existence and the validity of the FRAND agreement and to draw all legal consequences thereof. And that's why any other decision, for example, a direct application of the FRAND dance test, is a blatant violation of EU law.
That's a pretty bold statement, Cyrille, especially given the impression amongst SEP holders that French courts have an anti-patent bias. I mean, there certainly hasn't been a lot of FRAND jurisprudence coming out of France, because there hasn't been a lot of SEP litigation in France. Do you think if the view is changed, that FRAND is firstly a contractual matter, and secondly a matter of competition law, do you think that French courts would be happier to embrace SEP assertions?
Oh, yes. The answer is very simple. Yes. I do think that French courts, cannot wait to rule in this matter. This is what the president of the Third Chamber said at a recent conference. Because French judges, like most French lawyers, can only be upset when they see foreign decisions trampling on French law, as we have seen it too many times. Unfortunately, if I may say, most French cases which were brought before French courts over the past 20 years have been settled before the court could rule in this matter. But the willingness is there, for sure. And we have seen courts in a number of cases, recent cases, clearly welcoming this sort of SEP assertions. In comments made in a podcast on February 28th, Dr. Matthias Sidan, who was formerly the presiding judge at the Regional Court of Munich, he said that the assumption of any FRAND defense must be predicated on the fact that the defendant is an infringer of an SEP. In any action
related to setting a FRAND rate at a French court, would there be an assumption of validity and or essentiality over the essential patents?
Yeah, well, to the extent the implementer would not challenge the validity or the essentiality of the licensor's patents, a French court would not have the power to raise this issue by its own decision. That's very simple. Besides, the French court would not be competent, would not have jurisdiction with respect to the validity of foreign patents. If, however, the implementer challenges the essentiality, certainly of both French or foreign patents, the French court would have to rule on this issue. And the court would also have jurisdiction to rule on the validity of the French patents.
Would an injunction be granted by the French court if the licensor commenced a patent infringement action against an implementer?
If the licensor commenced a patent infringement action without asking for termination of the FRAND agreement, the answer would be no. The licensor is free to seek an injunction, let's be clear, from the Paris court. Provided, of course, that the FRAND agreement is first terminated for breach by the implementer and by the latter only. The court will indeed have to first rule on the question of the breach of contract, and any attempt to directly seek an injunction for a FRAND incumbent patent would be doomed to fail. So if the court determines that the implementer violated its obligations of the FRAND agreement and that the licensor complied with its own obligations, then it will terminate the agreement and award damages for the licensor for the past use. And the court will then be free to examine the infringement claims and enjoin eventually the implementer to practice patents for the future. That part of the case will be dealt with just like any other patent infringement case, with infringement contentions based upon a limited number of patents and with non-infringement and invalidity counterclaims. Now, if the court determines that the implementer did not violate its obligation under the FRAND agreement, or that whether the implementer was or was not at fault, if the court determines that the licensor did not comply with its own obligations, then the court will deny the licensor's request for termination. That's very simple contract law. The court may, however, find that in any event, damages are owed to the licensor for the past use, and it will then have to determine a FRAND rate and award damages to the licensor for the past. So as mentioned before, if the court issues a prohibition measure, the order can be subject to a suspensive or resolutive condition, and the parties will then have a very strong incentive to settle their dispute within the guidelines decided by the court.
How do you see FrandAvenue's role with regard to the proposed regulation that came from the EU Commission?
Well, we have seen this proposed regulation coming in recently, as many things have been said, written on that. It's funny because the existence of FrandAvenue is not mentioned in neither the regulation as normal, but also in the impact assessment report. Although, well, most of the competencies that would be given to the EU IPO Competence Center are kind of a copycat of what is already available on FrandAvenue, except that on FrandAvenue, this is made on a voluntary basis. For example, we offer a free access to SEP information. Anyone can go and find information on SEPs. And we also offer more sophisticated search tools which can be used with a subscription. There's a negotiation framework, and there's a dispute resolution mechanism, dispute resolution process, which in my humble view is much more efficient and flexible than the conciliation mechanism that is contemplated by the draft regulation. Well, we will see how it will be finally organized under the regulation to be adopted. and we will have time to review that. But anyway, I'll give you more insights about FrandAvenue in the next episodes to show you how all these issues that we have just briefly explained are covered by existing tools on Frand.
Okay, so thank you. That brings us to the end of today's podcast. Thank you very much. Very interesting. Our next podcast is going to dive into some of the specifics of the implications of applying French law, and which I think you'll find very interesting. They're a little bit surprising for me. And when is this next podcast scheduled for?
I think it's on May the 17th.
May the 17th. We'll send out more information.
We'll send out more information, and we will publish the script of this podcast and the recording, the video recording. Now, of course, if anyone has questions, we will be happy to take questions now or later.
Okay, we don't see any questions coming up in the sidebar, so we'll call it a day. And thank you very much for watching, and we look forward to having you with the next episode.
Thank you very much to all. Thank you.
Cheers. Thank you.